So, Madeleine, a lot of parents think that the fair outcome for when they separate is for the children to spend an equal amount of time with each of them. Is that something the courts are doing more frequently?
Well, I find this a really interesting area because it really goes to the heart of what our function is within the family justice system. And of course, we do need to reflect changes in society, and it is absolutely the case that parents now tend to share the care of their children more equally when they're living together. And when they come to the court, when they separate, if they don't agree on the arrangements, you may often get one parent saying, but of course it should be 50-50 because that's fair. But of course what the court has to do is apply the principle that the child's welfare is paramount and apply the welfare checklist, and fairness to the parents is not one of those considerations. So I think it is becoming more common that the courts will impose a shared care and equal shared care arrangement. But if the system is working right, then we should only be doing that when that is in the best interests of the child. It makes it all the more difficult, of course, when you have litigants in person coming to court who aren't aware of the legal tests that the court has to apply, and then really the judge has to make the arguments on both sides for the parents. But generally speaking, I think the way it ought to work is that the trend towards increasing numbers of shared care arrangements ought to be driven by what's happening on the ground and how families are living their lives. What we shouldn't be doing is imposing on families what a judge's idea of the right outcome is in any case. So I think they are increasing, but I think and I hope that that's because it's happening more commonly within families prior to separation, rather than because anything has significantly changed in the law.